Hello everybody. This is TJ at urlaw.org. This is another session to go over some interesting concepts as it relates to the syntax and grammar format argument for dealing with certain kinds of cases. Now at URLaw we teach multiple strategies and we merely show you information. It's a free information share of our private members, and one of the things we talk about is how the correct sentence structure, syntax, parse, grammar technology can work kind of in an everyday life application. A lot of people say, well, it can't work, it doesn't work, it's phony, whatever. Well, since when is good English and grammar, properly defined words, not relevant in a legal matter when all legal matters are about words? You know, they're words on a piece of paper that convict you of something, that draw you into this argument. And it's those words on that piece of paper that are the key to the whole thing. I call it the fly paper. So let's take a look at basically an example of an approach that some of our members have applied. Let's say they've taken some documents, they've done the forensic analysis and syntax of those documents, which is something that we do, we teach our members to do, and also we do as an additional service for fee on those people, on a fee based if necessary. So you can find out more about that as a premium member. But this idea is to help bring a forensic syntax documents into a court matter as an answer, because you have to answer, right? So do you want to answer and get into the argument, or do you want to answer and start challenging their documents, which is where you start? It's the beginning. So let me say this: for the learning claim is with the lack of legal advice by the presenter. Now in plain English that means this is not legal advice. You should seek legal counsel if you feel that it's necessary. And this is from urlaw.org. And if you want information on membership, you go to urlaw.org/join. You can become a free member first, just to kind of take a quick look around. But if you want access to our premium member content, you would need to then upgrade to the premium membership, and details on that are on the website. Now with this concept, you're answering by accepting their claim, not defending their facts. See, they're going to throw a lot of stuff at you in a document, a ticket, an indictment, a summons, whatever it is. And if you get caught up in that argument, you're going to have a problem. You're going to have a much greater, more difficult time fighting that battle. So what we're simply going to do is come right back and add conditions that they use proper grammar, syntax, definitions, explanation of boxings, certain characters on their page, that they're not using language fraud. That's our point. Now, we don't ever accuse them of fraud. We simply say, well, we accept your offer, but we need you to go ahead and correct some of this. And can someone else tell you that you understand something? Or can only you say that? This is the basis of this entire concept. People will say, well, this is phony, it doesn't work. Well, of course, because people get thrown off so easily because they presume they understand legalese. Well, what if a word has multiple meanings, as most words in the English language do? Where do they tell you the definitions that they are using? No, they get you to presume and assume you understand, because you think you understand English, but they're not using English, they're using what's called legalese. So you got to watch out. That's a trick and trap approach. So we only approach a situation as it's really only about their documents. Do you really understand them, or assume you do? And believe me, 99% of this is based upon assumption and presumption, and then your action. What do? Do you act as if you understand it? Do you really understand the terminology they're using? What if it has multiple meanings, or it's not defined at all? Then is it valid in a contract or complaint? Think if you had a business contract and there are words in there you didn't understand, would you sign it? Then why are you moving forward in this situation? So our strategy is to focus only on their indictment, the complaint, the ticket, and ask them politely and firmly, never accusing, correct the defects in language and grammar. And we show them what those are. And keep your arguments within the four corners of their document. Four corners rule. In other words, keep it within the four corners of the document. It's the document that's got you there. And when we reveal the defects, well, a defect equals no contract. So how can you possibly understand or agree to their documents if words, styles, and symbols are not defined within the document? Are you going to proceed on their presumptions and therefore volunteer and concede? And this is the key. All they need is you to volunteer and concede. If you enter a plea, it means you understood. Either way, guilty or not guilty. And if you've already done it, you can come back and say, hey, you know what, we need a more definitive statement here. I don't understand this after all. Okay, so if you start arguing their presumed facts, like I didn't shoot the gun, or I didn't have that marijuana in my possession, or I wasn't speeding, you start arguing, you've lost. They will try to draw you in when you bring this up. They're going to try to bring you back to their common way of doing business. You simply have to say, well, I'm happy to do that, but first we have to deal with this document, and I call it the fly paper that you're stuck to. Your answer to their complaint can simply be, we accept your offer with conditions, and then you need to stay on point. So what we do is we show you in our course on word power, it's called, how to create and submit a live-live claim, apply a definitions and styles sheet. We do them the courtesy of what they did not do for us. We give them a definitions and style sheet. And then we take all their evidence they gave us, which is their summons and whatever they sent you in the mail or delivered or arrested you and handed to you. That's your evidence. That's the focus of your evidence. It's not what they're accusing. It's the documents themselves. And then we do a syntax analysis of it where we break down the defects and the flaws that we see, and we ask them to correct it. And we attach a $1 stamp as consideration for our contract, a thumbprint, blue thumbprint, autograph, copyright, copy claim, put page numbers on it, and glue it together. The entire thing we submit to them, it becomes one 4 corners document. They never gave you a 4 corners document. Sometimes they don't even apply page numbers to their documents, so they're all each separate pages. It's a broken up contract. It's not one contiguous contract. So there's a lot of little tricks and traps they use just to get you to assume that there is something there. There is a contract there for you to perform under. But if there's defects in it, that's all you're going after. That's all we're going after. So you learn more about our Word Power course by becoming a premium member of Your Law. Free members don't have access, but the premium members do. So get over to yourlaw.org and you click the join link and learn more about that. So let's look at this document. This is just one example. This is not a template. It can be modified many different ways depending on your understanding. But if you're going to submit a document into their court case, obviously you need to use their court format, heading, and style. So first consult with that at their court. I can't tell you what it is. Their examples, and they can tell you what the style is. Okay, so there's a plaintiff. It might be the state of, the government of, the U.S., whatever it is. Then there's a name on there, typically an all capital letter name, or a name with a middle initial. Either of those are not your name. Get that straight from the beginning. And so what you're doing is asking for a more definitive statement. You're saying, hey, look, I can't answer this. I need definitions. I need a definitive statement made by somebody. So I, John Henry Doe, and this is the format that we teach in the syntax class, for the named defendant, John Henry Doe, moves this honorable court to enter an order requiring a more definitive statement regarding legal definitions being used in the plaintiff's documents. And you can say legal definitions and grammar if you want. We don't necessarily say that it has to be one way or the other. This is you're creating a contract with the court. The rule of plain language may be considered. However, defendant may still understand only certain grammar styles and definitions of words which the defendant commonly uses. This may be in opposition to the presumption of definitions being used by the plaintiff in court. So in other words, we're not just going to proceed on a presumption. We want to make sure everything's clear. And they'll come back and say, well, we're not going to do that. We're not going to define it. So you're going to tell me that I have to come into your court and you speak Chinese and I speak Russian, and you can force me into an agreement and to proceed when I don't understand what's going on. Well, they have an American Disabilities Act that requires courts to provide you interpreters if you speak a foreign language. We're using the same procedure here to simply say we don't understand the language and terminology because you didn't define it in a form that I can understand. So you when you do a motion, you always do short points and examples. Always one noun, one verb, one subject per sentence. Most people write long-winded motions and they lose because all they have to do is find one defect and then the whole point goes out. When you do it this way, you can make them rule on each point. And you want to compel the court. I need a ruling on each and every point, not the entire motion. This is how you win motions, folks. You've got to make it on each and every point, not the entire thing. So you break it into separate parts, okay? For example, you might say for the void of perjury. See, if they're committing perjury by using fictitious language on you and not telling you, that's perjury. So the defendant requires the correct sentence structure, parse, syntax, grammar, communication in all documents and proceedings. There's your terms. If you don't cite your terms and conditions, folks, you don't get it. Then for the void of perjury, defendant requires the use of, correct name, style, and spelling, and not a nom de guerre fiction trust name. And that could be this name up here is a nom de guerre. It's not actually yours. Go look up the term nom de guerre and you will find out that it's a reflection of something. It's not the actual thing. So just go look that up and come up with your own definition. 4. Defendant requires the use of definitions and styles as submitted in Exhibit A. Now that's where we're going to submit a definition sheet along with this as an exhibit. And you'll see what that is. I'm not going into that here today, but we give you that definitions and styles sheet that you would attach to this claim going back in. In Exhibit B, documents analyzed in relation to, and then you write their case number. So now they see that this is about that case number with the XYZ court. Whatever the name of their court is, use that court name. And it points to grammar issues and styles requiring correction before the proceeding. Okay? In other words, before you can proceed, you need this stuff defined. And here's and this is actually forensic evidence you're submitting back are just their documents. That's it. You're not getting into the facts of the case. Exhibit B may provide evidence of fictitious conveyance of language if not corrected fully. So what you're saying is, here's my forensic evidence. I need you to just give me a response to this. And they're going to come back and say, well, we don't have to. And I said, well, then therefore, I don't have to understand any of the words you speak to me. And you could say, if they say a word means something, you could answer as if it meant something else, because they refuse to give you a common language that you can communicate with, and also to correct their fictitious conveyance of language. And by the way, if you look at the definition sheet we give you, we also give you a list of the laws that when they do that, they're breaking certain laws. Conveyance of language is very important. So it has to do with postal laws and even several Title 18 laws that they're breaking by not doing this when you demand it. So you're setting them up essentially to just give you a correct name performance, give you a correct language and grammar performance. Let's agree how we're going to communicate before we proceed. That's not unreasonable. And people when they learn from David Wynn Miller, for example, he's very deep in understanding of this, but sometimes people miss the point. The point is it's just about what we're explaining to you here. We just want a common language and grammar performance, and we want to know that you're not using legalese, fictitious conveyance of language upon us. And if you are, though, and you won't do it, then we can't proceed. We don't have a contract. See, if you answer in any other way, you're agreeing there is a contract. We're saying there's a defect in the contract. It's that piece of paper that brings you all together. All right? So, and you're not refusing, you're not denying, you're not arguing. You're asking for performance and an agreement before you proceed. Very, very important. And if you've proceeded far enough into this, make this motion when you can, whenever you can. The earlier, the better. Day one, if possible. So, defendant moves the court to enter an order preventing plaintiff from using mere assumption of definitions and grammar styles being used in their case number 1, 2, 3, 4, 5, whatever it is. Plaintiff shall provide evidence that such definitions were previously known and agreed to by defendant previously when the alleged contract or crime took place. So if they're saying back 2 years ago when they say something happened, did they ever provide that to you? How could you possibly have what's called mens rea or criminal intent if they didn't even clearly define what the law was? This evidence and cooperation shall be admitted as evidence, so the plaintiff is not committing fictitious conveyance of language in their papers or charges which would be prejudiced and deprive defendant of their contractual and constitutional rights to truly understand the nature and cause of the matter. Guys, the whole name of the game is this syntax technology, folks. All roads lead back to this. Whatever technologies you've been studying out there on the internet, whatever gurus you've been studying, they've missed the whole point. It's all on the document itself. And then there are laws to support that. Communications laws. This is communications. So you signed it similarly how it was preceded. You always give a certificate of service saying who was served. And you always do a certificate of good faith. This is something a lot of people miss. I learned this from a very advanced studier and someone who's never lost a federal case said the key is you always have to go to opposing counsel first before filing a motion. People wonder why they have difficulty getting things into the clerk. It's because they never had a certificate of good faith going with it. You go to the other side and say, I'm going to be submitting this. I need to know if you want to stipulate, that is, to agree, or dismiss your case. You go to your brother first, Matthew 18 verses 15 and 16. If you skip one of those steps, things don't work out well. That's not just a theory. We've seen it over the years, over and over and over again. It really matters. So your certificate of good faith is critical to winning a motion. People wonder why the judge ignored my motions. Well, it says right there in the rules, at least in the local rules where I'm at in federal court, that alone can be a reason to dismiss the motion. Now, they may not talk about that and tell you that. They don't want to give you any clues, right? But that alone is sufficient to eliminate a motion. And you wonder why in your mortgage case or whatever, they just ignore everything. It's because you didn't follow the procedures. So we want to follow the procedures. Now, how do we know this is a procedure? We looked it up in our local rules. You got to know what a local rule is. If you don't know the local rules and you skip around and miss that, you're asking to lose your case. So we go and we say, and if they say we don't understand this, he says, how can you not understand not understanding? I'm asking you for these things to be corrected. And you show it to them. You have to talk to them. You can't be afraid of these people. You have to show them who is the king. Remember, the one who is asking is as king. And you need to go to them and say, look, we're just here in good faith. We are coming in good faith. We're not going to ambush you. We're going to ask you to give us a correct name performance. So you send it to them. You talk to them. And you don't just do it through the mail. Don't hide behind the mail. Go over meet them. Talk to them. Say, I need you to give me correct name performance. We're not here to talk about the case. We're just here to talk about this document and this language performance, this grammar performance. We just need to know this performance is going to be on an equal playing field. Now, of course, it's not. We know that. And they're probably going to deny it. We know that. But if you went in good faith and then you present the certificate of good faith when you submit the motion, your chances of getting heard are far greater than if you didn't. It's just biblical law. You may not believe in the Bible. I don't care. I'm telling you procedurally, it's in the rules of procedure as well for a reason. It works. So if you use the formula to your advantage, it'll work for you. If you don't, it won't. So I'm going to stress that if you're not a premium member of UR Law, first become a free member. You can do that. But then once you're a premium member, you'll have access to the Word Power course. And we have a full 10-hour seminar, a video seminar on the concept of word power. You don't have to know everything, but you really should before you proceed. And it shows you how to set up some of your documents, how to put this together. And then you get access to documents like the one we just showed you, which you can edit and you put together for your purpose. If it's not a court matter, if it's out of court, we also give you example documents you could submit as well with your syntaxed evidence that you send back to them. And again, you're taking the same position. We're here to settle this. I can tell you firsthand knowledge. I've done this on debt collector situations where they absolutely not only drop it, but they apologize really fast because we know that fictitious conveyance of language is a serious crime. And the legal system, for many people, is doing this to them. So avoid those kind of problems and get over to UR Law and check it out for more information. Thanks again.